Beltron?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yeah, sure.
All right. The court, I guess this is right from the jump. We're diving into a heated legal battle. The defendant, Luis Beltron, is about to challenge the very foundation of court's authority. Bold move or desperate gamble? Let's break it down.
Your Honor.
All right, so the first motion is a
Motion for a special appearance. Motion for a special appearance under the authority of Texas rules. Backhand index pointing right, VO commentary, legal insight. Okay, quick legal decode. A special appearance is usually a civil law tactic, not criminal. Beltron's basically arguing that the court doesn't even have a right to try him. Spoiler, criminal judges don't love that argument.
motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sage?
Judge, as a criminal district court, the court does have jurisdiction.
Judge explains felony jurisdiction. When a case is deemed by the penal code to be a felony, then that comes to a felony criminal court. Notice how the judge is in teacher mode here, breaking it down like a law school lecture. Felony court means felony case. Simple, right? But sometimes defendants try to win on technicalities before the trial even begins. Smart move, or just stalling tactics.
To preside over any matters, the defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Bexar County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand?
Mm-hmm.
All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have...
Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling? Okay.
Yes.
The
next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy, no injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction. The court just ruled that they did, that then the indictment would not be valid in this case. So I think that's what the client is trying to say.
It explains aggravated robbery indictment, a threat by using a deadly weapon. And so that is the harm. Here's the turning point. The prosecution isn't playing word games. They're painting the picture of an aggravated robbery with weapons involved. That instantly raises the stakes. And remember, folks, even threatening with a deadly weapon is enough for felony territory.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltron, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? You gonna have any questions about the court's ruling? All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been in law school.
Judge on Seventh Amendment confusion. The Seventh Amendment applies to jury trials in federal civil cases. This is a classic mix-up. Defendants sometimes throw around constitutional amendments hoping one sticks. But the Seventh Amendment? That's about civil jury trials, not criminal robbery cases in Texas. The judge swats it down fast.
Like, for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. I don't know. I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no-fault immunity third-party benefit in violation of the 7th Amendment. All right. Do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to being a third party brought in here without abstract subject matter jurisdiction, and the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right. State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay.
Yes.
That is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
All right. So the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say,
Defendant asks about cross-examining the state of Texas. How do I cross-examine the state of Texas? Now, this is an interesting moment. Beltron's asking how he can cross-examine the state of Texas, like it's a single witness on the stand. But in reality, you can't put a whole state in the hot seat. Instead, you go after the witnesses the state calls. Still admit it, you kind of wish you could see a lawyer try to grill an entire state, right?
explain it to me. You're saying district court is criminally attempting to receive an unauthorized, colorable, no-fault immunity? What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that? All right. So then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 U.S.C.S. 841. This court now under federal questioning under Title 28 U.S.C. 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltron.
I guess what I'm trying to say there, Your Honor, is how the state of Texas plaintiff, and they're the ones that are pursuing to prosecute me, which is they're the form of third party.
Okay.
And I don't third party. I'm not sure how that works. I know how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual.
Yeah,
if it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So,
Judge denies ex parte relief. That will be denied. And there it is, the first big ruling of the day. Motion denied. The judge is making it crystal clear. This case is going forward. But here's the question. Are these motions genuine legal strategy or just a way to clog up the system and buy time? What do you think?
In cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bexar. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand?
I understand.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next one? Are there any other things in here? Because some of it is repeats itself? Were those the main points?
Other than anything.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls. Okay, so that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mm-hmm.
My client is not wanting to have that heard right. It deals with ineffective assistance of counsel,
Mm-hmm.
right? Mr. Beltron, that's not to be heard.